In September 2023, the Ministry of Education and Sports introduced the new guidelines discouraging students from getting pregnant before completing their programs of study. The guidelines, signed by then Permanent Secretary Mrs. Kate Lamaro, state that students found pregnant and reported to the administration shall be granted leave and reported back after delivering and breastfeeding the child for a period of 6 months. Alternatively, readmission shall be conditional on whether the student reported the pregnancy voluntarily, has a good disciplinary record, and satisfactory academic performance. However, these guidelines have had a negative impact on some students. A case in point is Namukisa Sarah, a 25-year-old student from the Medical Laboratory Training School in Jinja, who was discontinued from sitting for her exams in a letter issued on May 16, 2025, after she was discovered to be pregnant. This incident has attracted the attention of humanitarian organizations and human rights defenders, who argue that Sarah, being above 18 years old, has a right to education despite her pregnancy status. Today, the Uganda Association of Women Lawyers, FIDA, and other women-led organizations have filed a constitutional petition challenging the violation of Sarah's and other girls' students' rights, particularly under Articles 21, Equality and Freedom from Discrimination, 33, Rights of Women, and 30, Right to Education.
Where students from the Medical Laboratory Training School in Jinja were also suspended and discontinued, discontinued because they were found pregnant. And while efforts have been made, especially before the Opportunities Commission, challenging the actions of the school, and the students have in the interim been allowed to sit for their exams, we are coming before the Constitutional Court to challenge the regulations, which are also another layer of authority under which the training institutions are in fact subjecting students to mandatory pregnancy tests against their will, and also suspending and discontinuing them because they have been found pregnant. So we are coming here to see to it that the regulations are declared null and void, and their continued implementation is put to a stop.
Hello, my name is Angela Sarah from MEMPRO Uganda, and we are here backing up FIDA in taking this constitutional petition to nullify the regulation that prevents pregnant girls in health institutions from going to school. Now at MEMPRO Uganda, we believe that women, just as men, should have access to education, and such laws are firstly very unconstitutional and should be removed, but also from a social and economic perspectives.
According to Susan Ibaluka, FIDA, Uganda's manager of strategic litigation, there is optimism that the petition will be resolved in accordance with the law.
We are hopeful that we shall succeed, basing on the arguments that we shall make, which, because of the rules on matters that are pending before courts, I cannot delve into, but that is why we are before the Constitutional Court. The other side will bring their arguments, we shall also bring our arguments, but we are confident that we shall succeed with our arguments, especially since we are of the view that the arguments on the other side on as to why they have those regulations in place do not necessarily meet the criteria for exceptional circumstances where rights can be limited.
Statistics show that over 30% of school dropouts occur in secondary schools, and over 40% in tertiary institutions, often due to various factors. The question remains, will the intervention of human rights defenders yield positive results? Serena Naguja for NSTV.